Unit 24, Loan Documentation. JAIIB, Principles and Practices of Banking, Module B. Page number 80. The term document has been defined differently for the purposes of different laws. As per Section 2(14) of Indian Stamp Act, it includes every document by which any right or liability is or proposed to be recorded. Under Section 2(18) of General Clauses Act 1897, a document shall include any matter written, expressed, or described upon any substance by means of letters, figures, or marks, or by more than one of these means, which is intended to be used for the purpose of recording that matter. The definition given in Section 3 of Indian Evidence Act 1872 or Section 29 of Indian Penal Code 1860 is also more or less on the same lines. Different types of documents. 1. Demand promissory notes. In loans where repayment is not for a fixed period, DP notes are obtained. These meet the requirement of Section 4 of Negotiable Instrument Act. Besides, these should be stamped (5 paise for amount up to rupees 250, 10 paise for amount above rupees 250 and up to rupees 1000, and 15 paise for amount above rupees 1000). Unstamped DP notes as per provisions of Indian Stamp Act cannot be used for filing of suit. 2. Agreement. Loan agreement or other agreements are required to be stamped as stamp duty rate prescribed by state government. Important agreements can be for pledge, hypothecation, assignment, mortgage, etc. The stamp duty on these differ from state to state. Procedure of documentation. For proper documentation, the following procedure is required to be followed. 1. Selection of correct set of documents, as documents differ with different loans, securities, different loans, different borrowers. 2. Payment of stamp duty, as unstamped or unstamped documents cannot be used for filing suit. 3. Completion of documents is essential, as incomplete documents, if used for filing suit, will result in dismissal of suits. 4. The precautions are given as under. 5. Legal formalities like registration of mortgages, registration of charge with registrar of companies in case of loans to companies, are also required to be completed. 6. Limitation. Documents are also required to be kept in force, for which separate details are given. Execution of documents. It means signing (and attestation or witnessing whenever necessary) of a document with intention to create contractual relationship. The person signing the document should not be incompetent to sign, such as a minor, insolvent, or insane. He should be competent to enter into legal contract. Date of document is the date stated in such document. The date is important for the limitation purpose, for production of a document, for registration wherever applicable. for arriving at due dates or maturities, etc., of bills drawn under NI Act, or for complying with statutory requirements such as filing of particulars of charge, etc., under Companies Act 1956. Different dates. If different parties put their signatures to the document on different dates, the date on which the last party signs the document may, subject to the consent of parties, by written as the date of document. If no document is stated under the signatures, the date of document will be the date. Place of execution and signatures. It is important for deciding jurisdiction of a court in the event of any dispute with regard to the subject matter of a document is required to be settled through a court of law. Signatures of the parties executing the document should be taken at the bottom of each page of the document. Open bracket. For legal binding, signatures on last page even are adequate. Close bracket. Against the execution or testimonium clause, and at the bottom of each page, the page of schedules, all types of interlinings, alterations, insertions, cuttings, overwritings, erasing, deletions must be properly authenticated by the executants under their full signatures. If a person signs with left hand, the fact should be indicated below the signatures. In case of signatures in vernacular or illiterate, a certificate duly witnessed to be given by the manager regarding explanation of the contents. Page number 81. Who is to sign the documents? 1. Borrower, individual. Who is to sign? Himself or his agent. 2. Borrower, joint borrowers. Who is to sign? All or their agent. 3. Borrower, proprietorship firm. Who is to sign? Proprietor or his agent. 4. Borrower, partnership firm. Who is to sign? All partners. 5. Borrower, HUF. Who is to sign? Karta. If compartners are to be made personally liable, they are also to sign. 6. Joint stock company. Who is to sign? Person authorized by the resolution from Board of Directors. 7. Borrower, trust or club or societies. Who is to sign? Trustee or people authorized by their governing documents or resolutions. Who should not sign? Minor, insolvent, lunatic, people of unsound mind, heavily drunk people are not competent to enter into a contract due to which they cannot sign valid documents. However, in case of a Pardanashan lady, the contract voidable at the option of the lady. Illiterate people or blind people, being competent to contract, can execute valid documents. Form of documents. The form of documents depends upon A. Type of security, that is goods, vehicle, machinery, bills, etc. B. Type of borrower, that is individual, partnership firm, company, etc. C. Type of charge, that is pledge, hypothecation of or mortgage, etc. And D. Type of credit facility, that is cash credit, term loans, etc. Witnessing of documents. Witnessing under Section 3 of Transfer of Property Act means attesting of documents by two or more witnesses, each of whom has seen the executants sign or affix his mark on the instrument. It is to be done by a person who is not a party to the transaction. If a document is required to be witnessed and is not witnessed, it will be treated as not executed. A document should be executed first and then witnessed. Following documents must be witnessed: mortgage deed, sale deed, guarantee deed, power of attorney, assignment on the instrument itself, example LIC policy, assignment by separate instrument, a will, and all other documents requiring ad valorem stamp duty. Following documents need not be witnessed: a cash credit or overdraft agreement, agreement of pledge, agreement of hypothecation, demand pro note, letter of line, letter of continuity, letter of set off, letter of guarantee, usance pro note or bill of exchange, and agreement of hypothecation of book debts. Other precautions in documentation include not handing the documents to the borrower for signatures, signing of documents in full signatures, mention of date and place clearly, etc. Stamping of loan documents. The Stamp Act extends to whole of India except J&K. In all, there are 65 documents requiring stamping. All documents chargeable with duty and executed by any person in India should be properly and duly stamped as per provisions of Indian Stamp Act 1899. Powers of central government. In respect of instruments mentioned in entry 91 of Union List, that is 10 instruments, namely demand promissory note, bill of exchange payable otherwise than on demand, check, bill of lading, letter of credit, share transfer form, debenture, proxy, insurance policies, and money receipts. The duty will remain same throughout India. Power of the state government. The state governments can amend the act or enact a new act and prescribe rate of stamp duty for instruments other than those in the Union List. Total income from stamp duty as per Article 268 is credited to consolidated fund of the state and it is assigned to the state where it is levied. Different kinds of stamps. These are the different kinds of stamps, that is judicial, open bracket, used as per Court Fees Act for filing of suits, etc., close bracket, non-judicial, open bracket, used as per provision of Indian Stamp Act for commercial transactions, close bracket, and postal stamps. Non-judicial stamps. Non-judicial stamps are used in bank documents which are of three types, namely adhesive, special adhesive, embossed or impressed stamps. Time of stamping. Documents must bear the current stamp and must be stamped before or at the time of execution. Section 17. Value of stamp duty. Where there is doubt with regard to proper value of stamp duty payable, collector of stamp duty will decide the proper amount of duty. Section 31. Effect of non-stamping or understamping. Section 35. All documents including promissory notes, a usance bill of exchange, and acknowledgement of debts which is unstamped or inadequately stamped can be validated by payment of duty and penalty as per the state government permission. Penalty for understamping or non-stamping. State government may impose fine which may be minimum ₹5 and maximum up to 10 times of such duty or deficient portion. Page number 82. Further, any person executing a document which is not duly stamped is committing an offence which is punishable with fine which may extend to ₹500. Cancellation of adhesive stamps. The adhesive stamps affixed on a document or instrument should be cancelled by the executant by writing on or across the stamp his name or initials, or in any other effectual manner so that the stamp cannot be used again. Section 12. Non-judicial stamp papers need not be cancelled as these cannot be used again. Effect of non-cancellation. Any instrument bearing adhesive stamps which have not been effectively cancelled shall be deemed to be unstamped. Section 12(1). Special adhesive stamps or embossed or impressed stamps should not be cancelled while executing documents. Nothing should be written across these stamps. Double signatures. Double signatures of the borrowers, one across the stamp and other without stamp, should be obtained on the pronote or any other document requiring adhesive stamps. Execution outside India. Any promissory note executed out of India and stamped at the time of execution with the proper Indian stamps is subsequently brought to India will have to be stamped again by the first holder within 3 months of its arrival in India. In case of negotiable instruments, it should be before negotiation by first holders. Section 18. Refund of obsolete stamps, unused or spoiled documents. Application can be made to district collector for refund under section 50 to 54. If document is not older than 6 months, 90% is available for individuals. For bank, it is 100% at any time. Stamp duty rates on various important instruments. Instrument. Receipts for any money or property the amount or value of which exceeds ₹500. Rate ₹1. Instrument. Proxy. Rate 15 paise. Instrument. Letter of credit. Rate ₹1. Instrument. Transfer of shares. ₹100 or part. Rate 25 paise. Instrument. Demand bill of exchange. Rate nil. Instrument. Check. Rate nil. Instrument. Demand promissory note. Value not more than ₹250. Rate 5 paise. Instrument. Demand promissory note. Value is greater than rupees 250 but up to rupees 1000, rate 10 paise. Instrument demand promissory note, value is greater than rupees 1000, rate 15 paise. Instrument usance bill of exchange or promissory note, rate ad valorem. In case of instruments of transfer of shares by way of security to banks by shareholders and of transfer by banks to shareholders, the duty as above is restricted to rupees 7.50. In case of usance bill exchange, where the usance period is up to 90 days and bank or FI is a part, duty has been remitted WEF 1889. Important sections of Indian Stamp Act. Section 3. Summary of the provision. No duty is chargeable on the instruments by or in favor of government. Section 8. Summary of the provision. Securities dealt in depository not liable for stamp duty. Section 12. Summary of provision. Where duty is paid by way of adhesive stamps is to be cancelled, and where it is not cancelled, the document would be deemed to be unstamped. Cancellation can be by way of signatures across or crossing in such a manner that it could not be used again. Section 14. Summary of the provision. On a stamped paper, only one instrument is to be written. Section 17. Summary of the provision. Stamping before or at the time of execution. Section 18. Summary of the provision. Instruments executed outside India to be stamped within 3 months of first receipt in India. Section 19. Summary of the provision. Bill or notes drawn outside India, first holder to pay before acceptance or payment of or endorsement or transfers otherwise. Section 29. Summary of the provision. Stamp duty is payable by people drawing or making or executing such documents. Section 31. Summary of the provision. Collector is to decide whether proper stamp duty has been paid or not. Section 33. Summary of the provision. If a person finds that such document is not duly stamped, he will impound the same. Section 35. Summary of the provision. Instruments which are not duly stamped are inadmissible in evidence. Section 43. Summary of the provision. A person can be prosecuted for offence against stamp law even after payment of penalty. Section 45. Summary of the provision. Chief Controlling Revenue Authority has the power to refund any penalty upon the application made in writing within 1 year. Limitation of loan documents. The provisions regarding limitation are contained in Limitation Act 1963, applicable in India except the state of Jammu and Kashmir. Page number 83. Limitation period. Limitation period is the time limit within which the parties to a legal agreement can take action in a court of law to enforcement their legal right. Expiry of limitation period does not take away the right of recovery of the debt, as it bars only the remedy of filing a suit. Hence, there is no limitation period for exercising the right of lying or set off and selling the securities pledged. That is where remedy through court is not required. Computation of limitation. In computing the limitation for any suit, the date from which such period is to be reckoned shall be excluded. The suit can be filed on the anniversary day. Section 12. The limitation in respect of various documents or transactions is as given in schedule to this section. The limitation period cannot be shortened or lengthened by mutual agreement. Section 28. Period to be excluded for computing of limitation. A. Closure of courts. Section 4. The suit can be filed on the day when the court reopens if the limitation period expires on that day when court is closed, even where the suit is filed in the wrong court inadvertently, but in good faith. The time consumed in such proceedings can be excluded for computing the period. B. Injunction. Section 15. Where a person is restrained by way of injunction from a court to enforce a legal remedy, such period is excluded from calculation of limitation period. C. Absence from India. The period of absence from India would be excluded. D. Court jurisdiction. Where a case pursued bona fide in good faith in a court having no jurisdiction, that period would be counted for calculation of limitation period. Section 14. Limitation period extension. It can be extended by acknowledgement. Section 18, or by part payment. Section 19, but only before the expiry of the limitation period. A. Acknowledgements of debt means admission of liability by the liable party, which may be by way of revival letter, balance confirmation, or ordinary letter, including the one addressed to some other person admitting the liability, or in a balance sheet signed by authorized person. B. Part payment. A. If the debtor makes a part payment before the expiry of the limitation period, either by himself or by his agent duly authorized on his behalf, or in the handwriting of himself or such agent, fresh period of limitation starts from date of such part payment. B. A credit entry by itself does not save limitation. Pay-in slip signed by the borrower or his duly authorized agent amounts to part payment. A pay-in slip signed by an employee or of a partnership firm or a company does not save limitation. C. It needs to be noted that the acknowledgement of debt and part payment should be obtained before the expiry limitation period, as they cannot revive the limitation if already expired. Fresh promise to pay. Revival of limitation. Even after the expiry of limitation, the liability can be enforced if there is a fresh promise to pay. Express agreement. The outstanding debt already barred by limitation, because under section 25(3) of the Contract Act, a time barred debt is a valid consideration for a fresh promise to pay. Limitation period against guarantor. Supreme Court in Margaret Lalita Samuel versus Indo Commercial Bank held that the limitation against the guarantor does not begin unless a demand is made on the guarantor to pay the debt. Who is to sign the acknowledgement? 1. Borrower, individual, who is to sign himself or his agent. 2. Borrower, joint borrowers, who is to sign all or their agents. 3. Borrower, proprietorship firm, who is to sign proprietor or his agent. 4. Borrower, partnership firm, who is to sign all partners or authorized partners. 5. HUF, who is to sign Karta if co-signers have been made personally liable, they are also to sign. 6. Borrower, joint stock company, who is to sign person authorized by the resolution from board of directors. 7. Borrower, trust or club or societies, who is to sign trustee, people authorized by their governing documents or resolutions. Loan account-wise limitation period. 1. Demand loans, 3 years from date of loan. 2. Demand promissory note, 3 years from date of DPN. 3. Temporary overdraft, 3 years from the date of loan. 4. Term loan, 3 years from due date of each installment. 5. Cash credit hype, 3 years from date of document. 6. Cash credit pledge, not applicable. 7. Bill discounting, 3 years from due date of the respective bill. 8. Bills purchasing, 3 years from date of bill. 9. Loans secured by mortgage, instead of 3 years the period will be 12 years. 10. Recovery of loss caused by fraud, 3 years from date of fraud detection. 11. Suit by central or state government, 30 years from the period of when limitation begins. 12. Right of foreclosure and right of redemption in case of mortgage, 30 years when money becomes due and when right to recover accrues respectively. 13. For balance due on a mutual, open and current, 3 years from close of financial year in which last item is admitted. Page number 84. 14. Account or cash credit account. Deposit accounts like SP, CA or matured FDRs, 3 years from date of demand. 15. Appeal to High Court against lower court, 90 days from date of decree. 16. Appeal to other courts on the decree or at lower court, 30 days from the date of decree. 17. Execution of decree, 12 years from date of decree. Important sections of Limitation Act 1963. Section 3. Summary of the provision. Application made to a competent court after the prescription period shall be dismissed. Section 4. Summary of the provision. If court is closed, the suit may be instituted on the day when court reopens. Section 5. Summary of the provision. If applicant satisfies the court about not making the application, court can admit the suit. Section 6. Summary of the provision. Where a person is legally disabled, minor or insane, the period of disability will be excluded to calculate the running of the period. Section 9. Summary of the provision. Once time has begun to run, no subsequent disability or inability to institute a suit stops it. Section 12. Summary of the provision. Day from which limitation period is not reckoned to be excluded. Section 14. Summary of the provision. If plaintiff has been prosecuted, another civil proceedings period shall be excluded. Section 15. Summary of provision. Period of injunction by other court to be excluded for calculation of limitation period. Section 18. Summary of provision. Acknowledgement before expiration of prescribed periods gives fresh period of limitation. Section 19. Summary of the provision. Payment by the debtor or his agent before expiration of prescribed period provides fresh period. Securitization. Securitization is a process through which the future receivables open brackets say installment of a term loan due in future sanctioned by the bank close bracket of a bank are converted into marketable paper or demat instruments such as bonds with a fixed rate of return and sold to investors. Parties in securitization. Originator, the bank which offers assets for securitization to meet need of cash. Special purpose vehicle, SPF, a company normally promoted by an institution that will purchase the loans for securitization. The assets are held by the SPF on behalf of investors in pass-through certificate to ensure that the investor's interest is secure even if the originator goes bankrupt. Qualified institutional buyers. These are the investors in the pass-through certificates. Pass-through certificates. These are the instruments like bonds or debentures which are issued by SPF and purchased by qualified institutional buyers. Under SARFAESI Act, the securitization companies or reconstruction companies play the role of SPF. The marketable paper or demat instruments are called security receipts. Terminal questions. First question. Execution of documents means signing and witnessing if required with the intention of. Answer. Creating contractual relationship, that is laying terms and conditions the respective parties say, bank and borrower. Next question. Name the people who cannot execute or sign a document to make it a binding agreement. Answer. Minor, insolvent, lunatic, or people of unsound mind. Next question. Every document bears a date. What is the importance of date in a document? Answer. Calculation of limitation period, compliance of statutory formalities like registration of charge. Next question. What is the importance of a place in a document? Answer. To determine the jurisdiction of court and payment of stamp duty. Next question. If a document bears more than one dates, it will be assumed to be executed on which date? Answer. The date on which the last party signs the document shall be treated as the date of document. Next question. If below the signatures no date is put by the signatory, the document would be considered to have been signed on. Answer. On the date of document. Next question. Where the signatures of the parties should be taken on a document. Answer. Signatures on the last page of the document, all schedules attached to the document, and confirmation of all cuttings, deletions and additions. Next question. Who can sign a document on behalf of an individual? Say A. Answer. Himself or his agent. Page number 85. Next question. Who can sign a document on behalf of a partnership firm? Say ABC. Answer. All partners or their agents. Next question. Who can sign a document on behalf of a joint stock company? Say ABC Private Limited. Answer. Person authorized by the company through resolution of board of directors. Next question. Who can sign a document on behalf of an HUF concern? Say ABC HUF. Answer. Karta. If co-partners are to be made personally liable, they have to sign. Next question. What is the position of legal validity of documents signed by an illiterate person? Answer. As he is competent to the contract, he can execute valid documents. Next question. What is the position of legal validity of documents signed by a blind person? Answer. Can execute valid documents since he is competent to contract. Next question. What precaution is to be taken by the bank if the document is signed by an illiterate or blind person or a person signing in vernacular? Answer. In case of an illiterate person, a certificate duly witnessed and signed by the bank official that the documents were read before the illiterate person and he signed after understanding the contents should be placed on bank records. In case of a person signing in vernacular, similar certificate given by the borrower should be placed on bank records. Next question. What is meant by attestation of a document? Answer. Attesting means witnessing of documents by one or more witnesses. Next question. Attestation is defined under Section 3 of Transfer of Property Act as. Answer. Witnessing by two or more people, each of whom has seen the executant sign or affix his mark on the document, should not be executant. Next question. Name the documents which are to be compulsorily attested. Answer. Mortgage deed, sale deed, power of attorney, guarantee deed, assignment. Next question. Name few documents that are not required to be attested. Answer. Pledge agreement, hypothecation agreement, letter of line, set off. Next question. If a document requiring attestation is not attested, what would be effect on its legal validity? Answer. Document will be treated as not executed. Next question. If a document not requiring attestation is attested, what would be effect on its legal validity? Answer. Due to deficiency in payment of stamp duty, the courts will not accept the document as a primary evidence. Next question. If a document is originally signed in English and subsequently some confirmation is given by the same person in some other script, what will be the effect on the legal status of the document? Answer: the document would continue to be legally valid. Bank may face some problem in proving that the document has been signed by one person. Next question. Indian Stamp Act 1899 is not applicable in which states in India? Answer: Jammu and Kashmir. Next question. How many documents are there that require payment of stamp duty in India? Answer: 65 documents require payment of stamp duty. Next question. Name all for which levy of stamp duty is prescribed by central government. Answer: 10 instruments: promissory note, bill of exchange, check, letter of credit, bill of lading, share transfer form, debenture, proxy letter, insurance policy, money receipt. Next question. Name few documents for which levy of stamp duty is done by the state government concerned. Answer: power of attorney, mortgage deed, guarantee deed, cash credit or TL agreement. Next question. Total income of stamp duty as per Article 268 is credited to. Answer: consolidated fund of state that collects the duty. Next question. Name different kinds of stamps used by banks. Answer: non-judicial adhesive stamps, special adhesive stamps, embossed or impressed stamps. Next question. What is an adhesive stamp? Answer: stamps that are affixed on money receipt, demand promissory note such as revenue stamp, notary stamp. Next question. Where do the banks make use of non-judicial stamps? Answer: used in bank documents. Next question. What is the prescribed time period for payment of stamp duty as per Section 17 of Indian Stamp Act? Answer: document must be stamped before or at the time of execution, that is signing. Page number 86. Next question. If the duty is not paid before or at the time of signing of the documents would be called. Answer: unstamped. No court would admit such document as primary evidence. Next question. If full amount of duty is not paid before or at the time of signing of the document would be called. Answer: understamped. No court would admit such document as primary evidence. Next question. If there is doubt with regard to proper value of stamp duty payable, who decides the proper amount of duty under Section 31? Answer: collector of stamp duty. Next question. What is the effect of non-stamping or understamping of a document as per provisions of Section 35? Answer: such document would not be admitted by a court of law for the purpose of filing of a suit as a primary evidence. Next question. If a document is understamped or unstamped, what remedy is available to validate it? Answer: can be validated with permission of collector of stamp duty. Next question. What is the amount of fine payable if the document is to be validated with the permission of competent authority? Who is the competent authority for this purpose? Answer: Penalty minimum ₹5, maximum 10 times of duty or deficit portion. Competent authority is collector of stamp duty in a state. Next question. Which documents, even after payment of fine, cannot be validated at all? Answer: pronote, usance POE, acknowledgement of debt. Next question. What is the process of cancellation of stamp on a document? Answer: cancellation of adhesive stamp is done by signing across the stamp or putting a cross across the stamp. Next question. If a document is properly stamped but the stamp is not cancelled, what is the impact of its validity? Answer: deemed to be unstamped. Next question. If a document is executed outside India, what are the provisions for payment of stamp duty to make the document legally valid in India? Answer: it should be stamped within 3 months of its arrival in India. Say power of attorney. Next question. If a document is executed in more than one state and each state has different stamp duty rate, how the payment of stamp duty would be made? Answer: the difference amount should be paid before execution in the second state. Next question. If a document is to be executed in Jammu and Kashmir state and in Rajasthan state, how the stamp duty payment would be made? Answer: full duty payable in both states. Next question. Any person executing a document which is not duly stamped is committing an offence which is payable with fine which may be up to rupees. Answer: ₹500. Next question. Which is the competent authority to allow refund of obsolete, unused or spoiled stamps? Answer: collector of stamp duty. Next question. How much stamp duty is payable on a usance bill of exchange up to 90 days where bank is one of the parties? Answer: stamp duty is waived off on such instruments. Next question. How much stamp duty is payable on a demand bill of exchange? Answer: no stamp duty required to be paid. Next question. How much stamp duty is payable on a money receipt? Answer: ₹1 only when the money receipt is for an amount exceeding ₹5,000. Page number 87. Next question. How much stamp duty is payable on a letter of credit? Answer: ₹1. Next question. How much stamp duty is payable on demand promissory note? Answer: demand pro note up to ₹250 paise, above ₹250 to rupees. Demand pro note up to ₹250, it is 5 paise, above ₹250 to ₹1,000, it is 10 paise, and above 1,000 it is 15 paise. Next question. How much stamp duty is payable on a usance bill of exchange? Answer: ad valorem, that is according to value and according to time or tenor. Next question. How much stamp duty is payable on a usance promissory note? Answer: ad valorem. Next question. How much stamp duty is payable on a document by or in favor of government? Answer: nil. Next question. How much stamp duty is payable on securities dealt in depository? Answer: nil. Next question. Who is liable to make payment of due stamp duty? Answer: person executing the document. Next question. Certain documents are required to be registered. What is the objective of such registration? Answer: to give notice to the public, to prevent fraud or forgery, to ensure that people dealing with the property is aware of everything. Next question. Which documents need compulsory registration under Section 17 of Indian Registration Act 1908? Answer: mortgage deed, written memorandum of title deed, sale deed, assignment. Next question. Who can present the documents for registration under Section 32 of Indian Registration Act? Answer: executant or representative or assignee or POA holder. Next question. Under the provisions of Indian Registration Act 1908, which is the competent authority for registration of documents? Answer: Registrar of Assurance, under whose jurisdiction the property falls. Next question. What is the time period permitted under Section 23 for registration of documents? Answer: 4 months from date of execution. Next question. If the documents are not presented for registration within 4 months under Section 25, what remedy is possible? Answer: next 4 months can be extended by Registrar of Assurances for genuine reasons. Next question. If a document needs registration and is not registered, what are the consequences? Answer: cannot be admitted as evidence. It will not give effect to the transfer of interest or transfer of property. Next question. If the documents are executed abroad and are to be acted upon in India, what is the requirement relating to registration? Answer: must be registered within 4 months of arrival in India. Next question. What is the order of priority for registered and unregistered documents? Answer: registered document prevail over the unregistered document. Next question. What is the order of priority for registered documents? Answer: the priority would be in terms of date of execution of the documents and not the date of registration. Next question. What is meant by the words limitation period? Answer: within which the party can take action, that is, file a suit in the court of law for enforcement of their claims. Next question. Under the provisions of which act the limitation aspect of document is regulated? Answer: Limitation Act 1963. Next question. Limitation Act 1963 is not applicable in which part of India? Answer: Jammu and Kashmir. Next question. In which circumstances or credit facilities the law of limitation is not applicable? Answer: pledge, right of line, right of set-off. Next question. To what extent the limitation period can be lengthened or shortened by mutual agreement under Section 28 of Limitation Act? Answer: cannot be lengthened or shortened. Next question. How the limitation period is computed under Section 12? What will be the last day of availability of limitation if a document is executed on January 12, 2002, assuming 3-year limitation? Answer: the date of execution is excluded, 12th January 2005. Page number 88. Next question. If the court is closed and limitation expires during the closure period, what remedy is available under Section 4? Answer: the suit can be filed on the day when the court reopens. Next question. If bank is stayed by a court of law to file suit, what is the effect of such stay on the period of limitation under Section 15? Answer: absence period is to be excluded from limitation period. Next question. What is meant by extension of limitation period? When is it possible? Answer: extension of limitation period means extension in the time period available for expiry of the limitation period. Next question. What is meant by revival of limitation? Under what circumstances it is done? Answer: when limitation period expires, the revival of limitation is possible by way of fresh promise to pay. Next question. What are the methods which are used to extend the limitation period? Answer: before expiry of limitation period, the period can be extended by acknowledgement of debt or by part payment. Next question. What is meant by acknowledgement of debt? How is it done? Write down various methods. Answer: admission of liability. It is done by way of letter, balance confirmation, placing bank's name as creditor in the balance sheet. Next question. What is meant by part payment? Who can make the part payment to extend the limitation period? Answer: part payment means the payment of debt in parts by the debtors before the expiry of the limitation period, either by himself or by his authorized agents. Next question. If part payment is made by filing the voucher and without signatures, what is the position of extension of limitation period? Answer: it extends the limitation from date of part payment as per Supreme Court judgment. Next question. If part payment is made by signing the voucher and someone else has filed the voucher, what is the position of extension of limitation period? Answer: it extends the limitation from date of part payment. Next question. What provision is available for revival of limitation period under Section 25(3) of Indian Contract Act? Answer: fresh promise to pay a time barred debt is a valid consideration. Bank can revive the limitation in case of time barred debt through such fresh promise. Next question. What procedure is to be followed for revival of limitation under such circumstances? Answer: sanction of a fresh loan in consideration of a previous loan. This can be done by obtaining fresh promise to pay the said time barred debt. Next question. If acknowledgement is only for part amount, what is effect on limitation for the remaining amount? Answer: acknowledgement extends the limitation for the entire amount. Next question. Acknowledgements of debt can be made by the debtor to whom? Answer: to his creditor or to other parties. Next question. What is the position of limitation against guarantors? Answer: limitation against guarantor to pay the debt starts from the date when loan is recalled from the guarantor or failure of the borrower to pay the loan. Next question. If limitation against the principal debtor has expired, what is the position of limitation against the guarantor? Answer. Against the guarantor, it runs from date of demand from guarantor. Hence, it may be available against the guarantor even though it might have expired against the borrower. Next question. If the documents are signed in a different script and acknowledgements of debt in a different script, what is the effect on legal validity on such acknowledgements? Answer. Legally valid. Next question. What limitation period is available for mortgage related loans? Answer. 12 years. Page number 89. Next question. What limitation period is available for hypothecation related loans? Answer. 3 years. Next question. What limitation period is available for pledge related loans? Answer. Law of limitation does not apply in case of pledge, as bank need not go to a court for enforcement of security. Next question. On a bill of exchange or promissory note payable at fixed time after date, limitation is available. Answer. 3 years from the date when the bill or note falls due. Next question. For a balance of exchange payable at a fixed time after sight or after demand, the limitation period is? Answer. 3 years when the fixed time expires. Next question. On a promissory note or bond payable by installment, limitation period is? Answer. 3 years from due date of each installment. Next question. On a surety against the principal debtor, the limitation is available. Answer. 3 years from the date of demand from surety. Next question. On a term to depositor, the limitation is available. Answer. If matured, 3 years from the date of demand. If not matured, after maturity when demanded, 3 years. Next question. By a mortgage for foreclosure, the limitation period? Answer. 30 years when the money secured by the mortgage becomes due. Next question. For an appeal to a high court from any decree or order, the limitation is? Answer. 90 days from the date of decree. Next question. Who can sign acknowledgement letter for a loan obtained by a company? Answer. Person authorized by resolution of Board of Directors. Next question. Who can sign acknowledgement letter for a loan obtained by a partnership firm? Answer. Any partner or partners. Next question. Execution of documents means signing and witnessing if required with the intention of? Answer. Creating contractual relationship, that is, laying terms and conditions of the respective parties, say bank and borrower. Next question. Name the person who cannot execute or sign a document to make it a binding agreement. Answer. Minor, insolvent, lunatic, people of unsound mind, or drunkard. Next question. Each document bears a date. What is the importance of date in a document? Answer. Calculation of limitation period, compliance of statutory formalities like registration of charge. Next question. What is the importance of place in a document? Answer. To determine the jurisdiction of court and payment of stamp duty. Next question. If a document bears more than one date, it will be assumed to be executed on which date? Answer. The date on which the last party signs the document shall be treated as the date of document. Next question. If below the signatures no date is put by the signatory, the document would be considered to have been signed on. Answer. On the date of document. Next question. Where the signatures of the parties should be taken on a document? Answer. Signatures on the last page of the document. All schedules attached to the document and confirmations on all cuttings, deletions and additions. Next question. Who can sign a document on behalf of an individual, say A? Answer. Himself or his agent. Next question. Who can sign a document on behalf of a partnership firm, say ABC? Answer. All partners or their agent.